Thank you so much for that introduction. Hello, everyone, as you all trickle in, and welcome to our presentation titled The Rights of Pregnant and Parenting Students in California Schools. I'm Juliana Gessiato, a staff attorney at the California Women's Law Center, and I am joined by my colleague, Jessica Lee, who's a senior staff attorney at the Center for WorkLife Law and the director of their Pregnant Scholar Initiative. I'll hand it off to Jessica in a minute to talk a little more about her work, but I wanted to give you all a brief overview of what we do at the California Women's Law Center. So our mission at CWLC is to create a more just and equitable society by breaking down barriers and advancing the potential of women and girls through transformative litigation, policy advocacy, and education. Our core issue areas include economic security, gender discrimination, violence against women, and women's health. Naturally, then, advocating for the rights of pregnant and parenting students fits into multiple of our core issues and furthers our general mission. So I'm excited to be able to co-host this presentation for you all. Jessica?
Thanks so much. Happy to be here with you all today. I am Jessica Lee. I'm director of the Pregnant Scholar Initiative. We are a program of the Center for WorkLife Law based at the University of California College of the Law in San Francisco. We're a research and advocacy organization focused on ensuring that no worker or student has to choose between supporting their family, providing for their family, and continuing their economic advancement. So shouldn't have to choose between work, school, and family. At the Pregnant Scholar, we provide policy implementation coaching for schools and colleges that are looking to do right by their pregnant and parenting students. And we are the legal resource center on the rights of pregnant and parenting students nationwide. So we help folks understand what the laws require, and we also help pregnant and parenting students navigate the bureaucracies and many challenges they face on their campus. So really excited to be here with you today to talk through the rights in particular of lactating students, and also just share some wisdom for what we have learned partnering with so many students and administrators nationwide.
Great, thank you so much. So first, let's start with an overview of why we're even discussing this issue, why it's important to provide accommodations for pregnant and parenting students in schools. Let's see. So we have here some of the barriers that pregnant and parenting students face when they return to the classroom. They are victim to stigmatizing behavior that can make them feel singled out because they are pregnant or have children. They may be prevented from taking courses necessary to get into colleges or restricted from school activities more generally because of their obligations to their children. Often, parenting students do not have a secure and private place to pump milk or breast or chest feed. And ultimately, a lack of accommodations for these girls often results in them being pushed out of their regular schools and into continuation schools instead. So what all of these problems lead to, first, it's important to understand that while teen pregnancies have generally decreased over the last few decades, 18% of women aged 20 to 29 had a baby in their teen years, nearly 1 in 5 women. Pregnancy and birth are significant contributors to high school dropout rates among girls. Only about 50% of teen mothers receive a high school diploma by the age of 22, whereas approximately 90% of women who do not give birth during adolescence graduate from high school. These effects then continue on to higher education. Students who become pregnant as teenagers have a much lower probability of earning a college degree. This result is from a combination of factors, including the low high school graduation rates for pregnant students. And then for those students that did graduate high school, they'll be facing the barriers associated with caring for a young child while in college with those increased academic and financial demands. These educational factors then decrease opportunities for higher paying jobs. In 2022, women with bachelor's degrees earned a median weekly income of $1,254. Those with only a high school diploma earned about $754 a week. And finally, those without a high school diploma earned only about $593. And the demands of parenting at a young age without professional skills, higher education degrees, or high school diplomas leads to increased welfare dependency. This causes a cycle of poverty where children of young parents are more likely to drop out of schools themselves, and families become more dependent on public programs and benefits, which are becoming less available and less funded. So ensuring pregnant and parenting students' rights are respected through necessary accommodations helps break the cycle of poverty at the beginning and gives girls a more equitable opportunity going forward. So with all those statistics in mind and knowing the importance of providing protections to students who are parenting, Jessica will now discuss lactation accommodations required by law.
Thank you. And I think it's so important that we're talking about this because they're so often overlooked by folks who are working to support pregnant and parenting students. Yet, this is a top issue for folks who are calling our helpline, and certainly a top issue for the student parents I speak with regularly. So first, why are lactation accommodations important? Well, the American Academy of Pediatrics, alongside most, if not all, major medical associations, recommends 6 months of exclusive breastfeeding and continued breastfeeding for 2 years or as long as parent and child would like to continue to do so. The vast majority of babies born in the United States, something over 80%, start off being breastfed because of this medical recommendation, in addition to the many benefits that it provides, both mentally and physically. When nursing parents are away from their child, they have to continue expressing milk about as often as that child would typically feed. And if they don't do that, they're then at risk for all sorts of complications, including painful infections and illness. I've had students who've been hospitalized for these infections, and even decreased milk supply, which can quickly lead to that student not being able to feed their child. So this is incredibly serious, but thankfully the benefits are also pretty persuasive in my mind. Babies who are breastfed, who are fed human milk, are less likely to need to go to the doctor. They have lower rates of common childhood infections like ear infections, but even long-term illnesses such as diabetes and childhood leukemia. Parents who are breastfeeding also see better lower rates of certain cancers like breast and ovarian cancer and lower cardiovascular disease, right? So this is a huge health issue for parents, and it's also deeply personal. By providing consequence-free lactation accommodations, student mothers and parents can take fewer absences for sickness and for childcare. They miss less schoolwork, and they stay better engaged with their classes and peers. And on top of that, frankly, it's what they want, right? Forcing a student to choose between nursing their child and going to school is just cruel. No student should have to make that choice. Some, including some students I've worked with, have chosen to prioritize feeding their child. And some who are faced with that unfortunate choice are so disheartened by being put into that decision that they lose focus or they just decide to leave because they feel tremendously disrespected and unwelcome in their educational setting, which I know none of us want to see. Next slide. So now that we've talked about why it's important, I'm happy to share that there are some laws there that are going to protect students who are lactating and need support for that during their school day. The first law is Title IX. I'm hopeful that you all are at least familiar with it. Title IX has been on the books since 1972, requiring that any federally funded educational program or activity is prohibited from discriminating against someone based on sex. And that includes a prohibition on discrimination on the basis of pregnancy, childbirth, and related conditions like lactation, because they're related to a person's sex. So whenever you think about sex discrimination, you should also be thinking about pregnancy, childbirth, and related conditions, as well as motherhood discrimination. So there have been some protections for many years. Next slide. The Department of Education has released some guidance specific to lactating students. Back in 2013, they put out a Dear Colleague letter and some guidance documents that explained and encourages schools to designate a private room for students to breastfeed or pump milk, or to address other needs relating to lactation during the day. But there were two big problems with that. First of all, that letter was directed to schools. So those of us who work in the post-secondary space might know this. Faculty are often hesitant to associate with K-12. I've seen many colleges and universities say, oh, that's talking about schools. They don't mean us, right? The other big issue, of course, is that it's an encouragement. They did not say that schools absolutely had to do it, and they did not give explicit details on what that space should look like and how to access it in a clear way that establishes an affirmative right. Thankfully, that is going to change very soon. Next slide. So the Title IX regulations are up for an update. They have not been updated in the section relating to pregnant and parenting students since the 70s. Thankfully, the Biden administration is currently reviewing the Title IX regulations. They proposed some new regulations. The public comment period was last year. We are anxiously awaiting these new regulations. We heard they would be out in May. They weren't. We heard they'd be out in October. They weren't. So now it's any day now, we're going to get new Title IX regulations that provide more affirmative rights to pregnant and postpartum students. Those new federal regulations, as drafted, as proposed, did explicitly require institutions to provide a lactation space that is clean, private, and not a bathroom. And they state very clearly that that space must be available to students to breastfeed or to express milk. And those students should also have some time to use that space without academic penalty. So, of course, we don't know the exact wording that's going to be present in the final federal regulations, but I am very hopeful that the wording in the proposal is going to carry on, that we're going to see this very explicit right to student lactation accommodations. And I should say, for those of you who haven't yet looked at the new Title IX proposal, I really encourage you to do so. Lactation accommodations are just one piece of the accommodation puzzle. And the new Biden administration Title IX regulations are also going to have a much more clear mandate to provide accommodations for students who are experiencing other conditions related to pregnancy. Accommodations have been required for since the 70s. But because the regulations didn't have enough detail about how they should be provided or the full extent to which they should be provided, a lot of schools and colleges have been operating in a bit of a gray space. And the proposed regulations as written are going to get rid of all that gray. It will be clear in black and white that pregnant students and students who are experiencing pregnancy-related conditions are entitled to changes at school to allow them to have the full benefit of their educational opportunity, regardless of what limitations they may be experiencing or conditions they may be experiencing related to pregnancy. And it's very important to note Title IX, in addition to California law, for those of you who don't know this, because under Title IX, a student can sue. So if a student is not provided this lactation space, they would not have to follow complaint procedures at their campus or school system. They would not have to um, go through an internal process. They could actually sue right away, or they could file a complaint with the Department of Education for investigation. So this is, I think, it makes the stakes a lot higher for schools and colleges, and really, I think, is going to usher in a new era for folks where accommodations feel like less of a favor and more of an entitlement. Okay, that was a lot on Title IX. Let's talk about California law. Next slide. So California law, California is actually one of the first states and one of only a few states that requires lactation accommodations for students. If any of you in the room were involved in making that happen, give yourselves a big pat on the back, because this is unfortunately very rare. So California law has protections both for the K-12 space and also for post-secondary. Under the California Ed Code, schools must provide a separate space for milk expression that is not a bathroom. And of course, that's important because students are expressing milk for little babies with little immune systems. And even if not, I don't know how many of you would want to prepare your lunch in a bathroom. Students will have do have the permission to bring their breast pump to campus. So they'll be enabled to bring what they need to actually use that space as well, which is really important. Students are entitled to have access to a power source. And that's because breast pumps, the best ones, run on electricity, and they need to have that electricity to be able to pump milk efficiently and get back to their studies. Students are also entitled access to a place to store expressed breast milk safely. That could be a refrigerator, that could be a cooler in a locking space that folks know isn't going to get tampered with. And then finally, students are encouraged to file complaints about lactation accommodations through that uniform complaint process. So, that works for some folks. Soon we'll have both the option for an investigation and lawsuit or these universal complaint processes. I think it's going to be an interesting few years here. So I was just reading a little bit about the California law that regulates K-12. There is a very similar, near identical provision for folks at the CSUs and community colleges. There's also some building requirements there and some other tidbits that will impact them. And then all of this goes on top of existing California law that says that lactating parents have the right to feed their child, to breastfeed in any place, public or private, where that parent is otherwise allowed to be present. So that is also a pretty important context here, especially when we're talking, I think, about college campuses or places where sometimes access is restricted. The permission to breastfeed in those public spaces is really important. Next slide. Okay, let's talk a little bit about leave. Now, of course, leave interacts with these lactation issues because folks who are immediately postpartum, that's when they're figuring all of this out, and lactation tends to be or can be tricky to establish in the early phases. But of course, everybody needs a little bit of time to recover from birth, right? Let's talk about what that looks like in the school setting. So the primary guidance here is, again, Title IX. So again, when we're thinking about Title IX's ban on discrimination on the basis of sex, that includes bans on discrimination based on pregnancy, childbirth, recovery from childbirth. But Title IX does go a bit further and actually has some clear obligations for educational institutions on maternity leave. Students who are giving birth or who are pregnant or have pregnancy related conditions are entitled to take time off from their education for so long a period of time as is deemed medically necessary. So again, there's no cap. It's not 2 weeks, not even 6 or 8. It is as long as they need, based on the opinion of a medical professional. So that medical necessity is determined by the student's physician, not standard practice at someone's school. And it may include all kinds of things like medically necessary doctor's appointments, leave during pregnancy. We see that occasionally folks are on bed rest or they're experiencing complications and they need leave well before birth. They're entitled to time off for childbirth and recovery from childbirth, as well as post-birth absences. So we often see folks need time off because they are experiencing postpartum depression, and that can go on for months after birth. It's still pregnancy related, so it's still covered under this standard. So that leave has to be given for as long a period of time as is deemed medically necessary. And given the current climate, I also think it's worthwhile to mention that this applies to abortion or miscarriage as well. If you're working with a student whose pregnancy has ended, but they still need some time off, or they need time off for medical appointments relating to that, that is also covered. It is an extremely broad protection for anything pregnancy related. Next. So the next part is, okay, you have this time off, then what? The Title IX regulations also address that and say very clearly that following the absence, the student shall be reinstated to the status which she held prior to taking leave. So that means their space in a program needs to be held, right? Guaranteed readmittance to the program. I don't want to see folks requiring students to reapply, to pay additional fees. They should be able to continue like any other student would if they weren't facing this sort of pregnancy-related condition. There shouldn't be any penalty or grade deductions. We see this come up a lot where students are graded on their participation in a course. So if they're not in class to raise their hand because they were out giving birth, all of a sudden their grade is taking a hit. That's illegal for any absence that's medically necessary. The student also needs to be able to make up assignments. So if something was happening in that class session, or maybe they've missed a paper or an exam because of their pregnancy-related condition, they have to be allowed to make that up. And they have to be given the time to make that up in a that's fair and reasonable, right? We have a lot of students who call us because they come back to school and they're told, great, here's all your makeup work, you have a week. While they're managing a newborn and while the other students had a month or more to do that work. That is, I think, a pretty prime example of not reinstating the student to their proper status in a fair way. And then finally, for those of you who are working with folks in the post-secondary space, I want to flag that this time off, this protection for maternity leave, also includes stopping the clock on policies relating to time to degree. So if you have a ticking clock on your program, or maybe on a scholarship, or even an extracurricular, that all has to be frozen for that student who is who's taking time off for pregnancy-related condition. And you see here, I have this little note because every time I give this this talk, somebody at the end says, well, surely there's some exception here. Surely we don't have to give students unlimited leave. You do. The law does not provide any exceptions to holding that student's place for them to take medically necessary leave. So I encourage you to spread the word. Maternity leave for students is real, and it is incredibly important, especially as these new Title IX regulations are enacted. because they are getting much more clear on what this looks like and who is responsible. And I think folks should prepare for those additional legal obligations under the new regulations. All right, I'll hand it back to you now to talk about the ABCs of breastfeeding.
Thank you so much. Yes, with this, all the law in mind surrounding this, we're now going to turn to a report that CWLC began back in 2015 alongside ACLU SoCal and Breastfeed LA. We joined together to create what we call report cards for California schools based on their policies for pregnant and parenting students. Over the years, we've continued to update this data, some years for all K-12 districts, some years higher educational institutions. Most recently, it was a focus on Los Angeles County K-12 districts. So I want to talk about what we look for when we collect this data and some of the key takeaways and trends that we have found through this research. So first, here are our 5 criteria. We try to put ourselves into the shoes of a pregnant or parenting person to determine what they might look for when they're navigating their rights within the school setting. So the way we collect this data is first just through website searches to look for each of these criteria. And if we can't find something or it's unclear on the website, we'll then reach out to the school directly via email, via phone to try to make sure that our data is accurate. So the questions we ask are, first, is there an easily identifiable Title IX coordinator? So if a pregnant or parenting student needs to speak with someone about their accommodations, can they easily find the right person to talk to? Second, does the district have their board policies online? If you're looking for the rights you have based on your school's policies, you want to be able to access those easily online and find what you're looking for. Next, does the district have a lactation accommodation policy for employees? We were thinking here, like if you were a parenting student who needed to breastfeed or express milk, your first thought might be they must have a lactation room for the teachers who are doing this or the staff. So maybe that can apply for students as well. Next, does the district have a pregnant and parenting student policy specifically? That's extremely helpful for students in this position to be able to find the exact policy that explains their rights and what their school can do for them. And then 5, even more specifically, does the district have a lactation accommodation policy for students? And then this relates to a report card because we collect data on all these 5 criteria for each district. And if they have all 5, they get an A. If they have 4, they get a B, and so on. So when we're collecting this data, we do run into some difficulties in both gathering the data and in convincing schools to update their own non-compliant policies. So sometimes finding the right contact person is a difficulty. While every school does list their Title IX coordinator, it's often simply the vice principal or another administrator, and their only job isn't Title IX. So they are not responsive or they just don't know the law that well. And then also they might not be the right person to talk to about getting board policies available online, for example, or even updating board policies. So just getting in contact with the right person has become a challenge in itself. Second, a little more self-explanatory is just non-responsiveness, not getting calls back or emails back. If we can't find the right person, not being able to get directed to the right person, that kind of thing. The third here is hostility and defensiveness. Sometimes they don't want to share all of their policies, or they're unwilling to listen on how they should improve or where there are inadequacies in their policies that we have found. A lot of times they think it's going to open a can of worms, like, oh, if we interact with this group who's trying to tell us our policies are non-inclusive, then it's going to lead to a huge Title IX issue. Next, we have procedures versus policies. Often pregnant and parenting students could access accommodations if they asked, and it's the school's staff or administrators' procedure to provide those accommodations, but there's not a formal written policy. So there's this disconnect between, even though we don't have it written anywhere, we are doing this and we are doing the right thing. And then finally, the board approval procedures. It's a lengthy and bureaucratic process at times to get new procedures approved. So just trying to make sure that they meet these criteria of having the appropriate policies can just take a long time. Okay, and now let's actually look at some of the data. Here I have some comparisons from when we first ran the report in 2015 to the most recent 2023 update. And I do want to remind you that this is based on Los Angeles County K-12 schools. So this year, 93% of school districts had a lactation accommodation policy for employees, which is up from 33% in 2015. 100% of school districts had an easily identifiable Title IX coordinator, which is up from 23%. And I do want to point out that SB 1375 in 2016 passed and went into effect the next year in 2017. And this requires Title IX information to be posted on schools' websites. And so that might account for some of this huge jump from 23% to now 100% of schools showing that Title IX coordinator. Then there were this year 79% of schools that had lactation accommodation policies for students specifically, huge increase from 17% when we first ran the study. And then finally, my last point here is that of the 81 school districts graded, 62 received an A, which is 77% that hit all 5 of those criteria, where only 1 school district did that in 2015. So it's a huge jump. And then throughout the years, while the number of districts in compliance overall has tremendously risen, there are a few things I have here to note. So the first is that the same districts are not always remaining in compliance for each criterion. Some will have a policy available 1 year when we collect data, and then the next time we update the data, maybe a couple years later, those policies are gone or have changed or are no longer accessible. So this is a reminder of how important it is to continue collecting data, following up with schools, and promoting education and advocacy to the community at large. So school districts are being held accountable for maintaining proper policies and they don't slip backwards as we're seeing them progress. Second, I want to point out that consistently, the 2 criteria that we are looking for that have the lowest percentage of compliance are pregnant and parenting policies for students and lactation accommodation policies for students. So like the entire concept of this webinar, those are the 2 policies that these school districts most consistently lack. This underscores the importance of this kind of training and making sure our community members know the rights that pregnant and parenting students should have so that they can go and be advocates for those students in schools. And because I did just bring up lactation accommodation policies for employees, we do want to note a few new rights in this area. Jessica and I were discussing that we could probably do an entire separate training on pregnancy and parenting rights for employees. So this here is just going to cover these new federal regulations. So most school systems have policies for employee lactation breaks, like I just mentioned. But the law has changed and there are even greater rights for these employees now. So the first law here is the PUMP Act. It's a federal law that requires private non-bathroom space for milk expression for up to a year post-birth. Breaks can be taken as needed with no exceptions for the size of the employer. And pay may be required in some circumstances. Next, there's the Pregnant Workers Fairness Act, excuse me. It's a federal law that requires reasonable accommodations for pregnancy-related conditions, including lactation, and it provides that there is no time limit on pumping accommodations. And I don't know, Jessica, if you had anything to add to this slide, maybe like some differences from what protections there were previously.
Sure. Yeah. Again, this is one of those situations where California already had a law, and it did a lot of great work for lactating workers in our state. But the federal laws do go further on a couple of items. First of all, the California state law that we've been working with for many years now did have some reasonableness standards there. And in that space, a lot of employers saw fit to negotiate lactation breaks with their employees to try to schedule their employees' lactation breaks. But the Pump Act is it's pretty unique in that it requires that those breaks be available as needed, so based off of the employee's needs. So there's no reasonableness standard there. Those breaks have to be provided. And I also really appreciate that the Pump Act makes clear those times in which an employee has to be paid for their lactation breaks. There's only 3 states in the country that universally require paid lactation breaks, but under the Pump Act, salaried workers should continue to be paid as usual. You shouldn't dock salaried workers' pay for their pumping breaks. Um, Workers who are hourly should also be paid if they are taking if they're taking that break at the same time as a paid break. So for example, if they have paid lunch and they choose to pump during their lunch period, they should still be paid. And of course, if anybody is working while pumping, they should also be paid. So I think this is a really helpful law because it is taking things a bit further. There are new enforcement mechanisms. It's a lot easier for folks to actually bring a case in court. And on top of that, the federal law for lactation accommodations had been in place since Obamacare was enacted over 10 years ago now. But it always left out teachers, educators, and salaried workers were long left out. So this is a big change that I think is going to cause a lot of school systems and colleges and universities to reevaluate their policies on lactation breaks, which is really the perfect moment to be advocating for students as well. So while they're in there tinkering around, we want to make sure they're thinking equitably about giving that break time and space to everybody at that educational institution. So really I think the perfect moment for all of us to be having this conversation.
Great, thank you. Yeah, so before we move on to questions, I did just want to put up a slide with the information for both of our organizations. If anyone has further inquiries or they need help with, a pregnant or parenting student they know, or anything that we can help you with, here is the information for both the California Women's Law Center and the Center for Work-Life Law. And with that being said, let's move on and see if there are any questions here. Feel free to continue typing them as we answer others. So first, the question I see is if you can review additional changes or requirements that are a result of recent pregnancy-related legislation.
Yeah, so I touched on the Pump Act a lot. I think that is the big shift that a lot of folks are paying attention to right now, especially in the education space, again, because such a huge portion of the workforce was previously excluded from federal protections before. If you're curious about what that looks like, you can visit our website. I'll put this in the chat soon. Pregnantatwork.org deals with the employee side of things, and we have some guides there on the Pump Act and also on the Pregnant Workers Fairness Act. So that is a law that requires reasonable accommodations for pregnancy and related conditions for all employers with 15 or more employees. So that is another, I think, big shift for a lot of folks, but it pretty closely mirrors protections that we've had in California for a long time. I think it's just always important to note because, again, a lot of employers who have not been paying close attention to these issues are now bringing out those old dusty policies, taking a second look at what they're providing. So in the context of lactation that Juliana was just speaking about, the Pregnant Workers Fairness Act, all of those reasonable accommodation laws include lactation. It was only in 2013 that we had the first federal recognition that lactation is a pregnancy related issue in the employment context, which is wild that it's so recent. But that is the case. So if anybody out there that you're representing or you're working with needs changes at work in relation to their lactation needs, those are covered now under both federal and state law.
Great, thank you. And then the next question we have here is there a comprehensive list of all current California and federal pregnancy-related laws that you can share?
This is now on my wish list to do.
So I know actually that I think this came out of when we worked with ACLU SoCal and Breastfeed LA on this. But there is, I believe it's on our website. It's called Breastfeeding and Lactation Advocacy 101 Toolkit. I'll type that name in the chat. And I don't know the last time it was updated. So these newer laws and the newer Title IX regulations wouldn't be on it, but it does list the laws for employees and for students by federal or state. So there is something there, like I said, not updated. And Jessica, you're right. This is on my wish list now. We should make sure that's updated. But let me drop that in the chat really quickly. And then while I do that, let me throw another question out here at you. We have one here. Oh, this is great because I brought it up in the report card. Can staff and students share a lactation space?
I'd love to get your thoughts on this as well, but I will say a lot of educational institutions do not like to set folks up for that sort of situation. If you've never used a breast pump, you are partially undressed in most instances while doing that. So I think a lot of K-12 in particular are going to want to steer away from that. However, under the federal employment laws, the Pump Act, actually, and state employment laws, those spaces have to be free from view and intrusion. So that looks like a lock on the door, right? A sign that folks respect, curtains over windows. So ideally, that's going to be a space where the person using it is not exposed to other people, where they can have privacy. And in that sort of situation, it doesn't make sense to say this is off limits to one group or another, because everybody should be able to use that in privacy and comfort. But of course, that does mean folks are going to have to really, really carefully keep track of how many users there are of that space and make sure that they are making enough spaces so that people are able to get into those lactation rooms as they need them. Because again, there's that new legal requirement. We don't want anyone getting sued because their lactation space is overwhelmed.
Yeah, I had the same thought because it's a private space. Usually there's a lock on the door, no windows. In that case, I can see it being perfectly reasonable. If you have two breastfeeding students and maybe a couple breastfeeding staff members, that it's possible to share a room. But I completely agree. You just have to make sure that you're meeting the needs of the number of people who need to use that room. All right, we have a couple more here. I actually have one here too. I'm wondering if in your work, Jessica, there are unique needs or differences in students who come to you K-12 versus students who are on college campuses, and maybe what the biggest difference in their needs looks like.
That is such a great question. I deal primarily with college students, but I think the overwhelming thing that we see in this work is that the younger the student is, the less support they have and the more bias they're facing. Um, Working on college campuses, graduate departments, right? They are welcoming. There's photos of parents and kids. They have staff members who are trained in providing pregnancy accommodations and giving folks leave and helping people navigate childcare and all of those challenges. When you get to the undergrad level, those resources are cut in half.
Yeah.
And when we're looking at K-12, they're often really, really lacking. So that support is very absent. The bias is through the roof. And on top of it, just undergirding that whole context, there is a huge power imbalance. So often students in the K-12 space are given an ultimatum or given a path, and they don't understand that they might have some agency to change that path, to say, no, I don't want to go to a different school, or no, I don't want to come back a week after giving birth. They often think that the options they have in front of them are their only choice. And so I always encourage folks just to be so aware of that context when they're counseling young parents, because even well-meaning folks tend to put these students in a corner. And we really need some strong advocates out there fighting for them so that they understand all of their choices and the many rights that they have available to them.
Great. Okay, we have time for a couple more probably here. So you mentioned the new regulations requiring accommodations for things other than breastfeeding. What other kinds of accommodations are required or allowable?
Yeah, I love that under the new Title IX regulations, there are some examples listed, but really the options are endless. So that it's whatever that student needs to meet their health needs. So that could mean probably the most common one is a larger desk. I know those desks that have the chair attached to the writing area. It's impossible. Yeah, when you're 8 or 9 months pregnant, that there's no way that's going to work. But we've had reports of students being told to just sit on the floor, right?
Wow.
Or having, yeah, or the teacher saying, okay, you can take my desk, but how othering and weird is that, especially for a young, nervous parent? Parking passes, especially if someone's on a large campus or a place where students typically don't have easy access to parking near the facility. Um, Pregnancy related carpal tunnel is a really common side effect. Sometimes people need typists. For morning sickness, it could mean permission to be late to class or to just leave class without having to ask your teacher or professor for permission. So really, it's open to whatever that student needs. We've seen the full gamut, anything from changing testing locations to remote school. It should all be on the table for that student. So if there's somebody who's saying, I have to take leave because of my health, I'm always asking what other options were provided to you that would help you be able to stay in.
Right.
Or, sometimes folks feel like they just have to drop out. And that's when you want to start asking, like, what was offered to you? Who sat down and had a conversation with you about meeting your needs? Because all too often that right to accommodation is overlooked. And it leads to a situation where a student is discriminated against or ends up being kicked out entirely.
Wow, yeah. Okay, so we have one more question here. It says, based on the fact that anyone with a need must have a space to use as needed, and this is in the context of lactation, does this mean that if there are, for example, 10 people who need to breastfeed, 10 spaces must be provided or made available?
Yeah, I wish the calculus was so cut and dry. It's usually not. Folks often have lactation needs that are not on the same schedule. So one worker might be pumping at 10, the other at 11. The best approach is just to ask folks what their schedule is. I like a sign-up sheet that is very, very carefully worded to say, what are your typical times? if there is no room here available, we will find you another one. Um, that that tends to work for a lot of employers. But I think that the bottom line is it has to be available. So my typical approach is to encourage folks to try it out, track the usage, either through surveys or a sign in and out sheet. But definitely make sure everybody knows who the primary point of contact is if they don't have space available when they need it. Um, I know that schools are not always well equipped to meet all of these needs just right off the bat, and that's okay as long as there's a pathway for people having their needs addressed in a way that is equitable and in keeping with the law.
Great. Those are all the questions we have here. So thank you all for joining us and becoming better advocates in this really important area of law. And thank you, Jessica, for your expertise. We are going to hand it now back to Lac to finish up the presentation.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.